Yo, what's up? Sean G, live and direct, free Puff. Let me let the windows down in here. I was gonna go into Manhattan and go live and do this, but I'm not gonna do it. I'm gonna go later. I'm gonna go another time, so I'll do a longer live. I'm doing some other research. The appeal, Puffy has filed his appeal. It's dated appeals to the Second Circuit. This is for the Second Circuit Court of Appeals. Entered in this action on October 15th, amended on October 16th. That's my clean date. October 16th was my clean date, so this is definitely going to work. This appeal concerns a conviction and sentence. Notice is hereby given that Sean Combs appeals to the United States Court of Appeals for the Second Circuit from the judgment entered into this action on October 15th, 2025, amended on October 16th, 2025. Okay, so that was the date that the judge filed his judgment. The appeal was filed yesterday, October 20th, 2025. So this is fresh. This appeal concerns a conviction and sentence. Defendant found guilty by trial. Offense occurred after November 1st, 1987. Yes, the date of the sentence was October 3rd, 2025, and he's committed. The appellant is represented by counsel. Yes. Defendant's counsel, Puffy's counsel, Alexandra, A.E. Shapiro, Arado, and Bach, LLP. The assistant U.S. attorney's name is Emily Johnson, who we all know lost the trial with the Southern District of New York. United States Attorney's Office, Southern District of New York, 1 St. Andrews Plaza, New York, New York. Okay. So the appeal is filed. The cost was $605. All right, so Puffy's appeal is locked in. Not sure what is going to be appealed, whether it's the conviction or the sentence, probably both. I've gone over this so many times, and if you guys have followed me throughout the trial, I've been telling you that Alexandra Shapiro, who's one of the top appeal lawyers in the country, and that's facts, was already building her appeal throughout the whole trial. Alexandra Shapiro did not cross-examine not one witness. That's not why she was there. Alexandra Shapiro was there to keep tabs on the judge, which is what she did. Throughout the trial, Alexandra Shapiro held forth over Judge Submaranian. Probably in all actuality, I don't know this to be true. I don't have any knowledge of this, but I would bet $100 against a bag of doo-doo that Alexandra Shapiro probably has already been offered a district judgeship. But she probably doesn't want that. Alexandra Shapiro really is a judge acting as a defense attorney. She held forth over Judge Submaranian, Maureen Comey, Emily Johnson, Mitzi Steiner, Christine Slavic, whoever the other one was. She held forth over everybody on the prosecution, including the judge, the entire trial, because they knew who she was. The Southern District of New York prosecutors, when they saw her come in the courtroom, they knew what the fuck it was, that there was no games, there was no playing, that the best is in here. And she pretty much just made sure the rule of law was being followed. along with Jason Driscoll, they carried a whooping stick. So anytime anybody got out of line with any rule of law or precedent, Alexandra Shapiro and Jason Driscoll would say, pow, pow, pop them on the ass and say, get back in line. That's not how it goes. Alexandra Shapiro, we know, asked for 2 mistrials during the course of the trial, right? Once for the removal of juror number 6. And what was the other one she asked for a mistrial? She asked for a mistrial right after the perjury testimony given by Breonna Bogelin. Both of those mistrials were denied, as we know. Alexandra Shapiro filed for the Rule 29 acquittal, arguing that the evidence submitted by the Southern District of New York prosecution was insufficient to prove a Mann Act conviction based upon Puffy's behavior, his conduct. That was denied. She asked for a Rule 33 new trial for what is that, misjoinder? Spillover, misjoinder, I forget the proper term, where that a lot of the evidence that was presented throughout the trial to prove the RICO and to prove the sex trafficking would have not been allowed to be submitted if Puff was just facing a Mann Act charge. That the inflammatory evidence that was presented to prove the RICO and the sex trafficking tainted the jurors to make them come back with a conviction for prostitution. And that spillover misjoinder, I think that's the right term. That's what a Rule 33, in that Alexandra Shapiro requested a Rule 33 new trial, retry Puffy on just the Mann Act, right? That was denied. Furthermore, Alexandra Shapiro brought out, as well as Puffy's other lawyers, that if Puffy was tried on the Mann Act alone, his case would have not even been prosecuted, because it's Department of Justice policy out of Washington, D.C. It is Department of Justice policy that Mann Act cases not be brought unless and only if there's a financial profit motive, it's an ongoing business, it's a real legitimate prostitution business. Number 2, there is real actual sex trafficking going on. Number 3, there are minors involved. None of those 3 were present in Puffy's Mann Act conviction or his Mann Act charge. So his case by right really never would have been brought. Another thing that was an extraordinary circumstance which was brought up is that in typical Mann Act cases, the sex trafficking is with women with language barriers in regards to English. They're immigrants from other countries. They don't speak the language. When they get here, their madam or the brothel or the prostitution pimp takes their visas and their paperwork and, you know, renders them like incapable of going to authorities because they're here, they're undocumented, and it forces them to engage in prostitution to gain their freedom. This is the typical run-of-the-mill case. Puffy's case was, if they were prostitutes, these were male prostitutes. These were men, right? No other case out of the 900 cases, I think Jason Driscoll looked up, had this type of dynamic, right? And what it was is Jane and Cassie were his girlfriends, right? They were his girlfriends. Jane and Cassie were consenting adults. They were over the age of 21. They were consenting adults. Jane and Cassie arranged for the male escorts to come. Jane and Cassie set up the freak-offs and the hotel nights. Jane and Cassie paid the male escorts for the hotel nights and the freak-offs. Furthermore, in a typical prostitution case, the John or the trick typically has sex with the prostitute. Nowhere was it ever documented and proven that Puffy had sex with the male escorts. That never happened. Puffy pretty much exercising his First Amendment right, filmed these encounters, and then had sex with his girlfriends, never having sex with the prostitutes, which were the male entertainers. Never once in Judge Submaranian's sentencing opinion did he mention the male escorts. Not one time, not one single time did he mention the prostitutes, who was the supposed prostitutes. Not once. In his sentencing opinion, he focused on acquitted conduct. He said the word coercion 4 times, the word force 2 times, and violence and drugs countless times. This is acquitted conduct. The judge tried to say that under 3553 and under 3661, he is able to include this in his decision making for sentencing. But then there's also a Rule 826, which says that you can't use acquitted conduct to determine a defendant's sentencing guideline range, which is exactly what he did. In a letter dated July the 9th, not a letter, in an order dated July the 9th, 2025, it's online, you can get it. Judge Submaranian asked the prosecution and the defense to bring him back cases, precedent cases, dealing with USC 182421, the transportation of humans to engage in sexual conduct or something like that. 2421. And he said that the sentencing guidelines should come in at US 2G1.1, right? And if you look up that, exactly what he asked for on the sentencing guideline table, that's a sentencing guideline of a base offense level of 14. Puffy had 0 criminal history points. That gave him a sentence range of 15 months to 21 months. At the sentencing, Jason Driscoll told the judge that he's read over 900 cases, every Mann Act case on PACER, and the average sentence for a Mann Act case came back at 14.2 months or 14.7 months, something to that effect. Yet we know that at sentencing, Puffy, who was a first offender, the first criminal conviction ever in his life, was enhanced 13 levels to a base offense level of 27, and he was given 50 months for a Mann Act. This is unethical, unjust, and unconstitutional. We further investigated that Ruth Bader Ginsburg, Supreme Court Justice, was against using acquitted conduct at sentencing. Judge Submaranian was a clerk for Ruth Bader Ginsburg. But guess what? So was Alexandra Shapiro. Alexandra Shapiro was a clerk for Ruth Bader Ginsburg. They both clerked under Ruth Bader Ginsburg. Supreme Court Justice Sotomayor says acquitted conduct sentencing is not good, is unconstitutional. Clarence Thomas, Supreme Court Justice, said using acquitted conduct at sentencing is unconstitutional. Kavanaugh, Supreme Court Justice Kavanaugh, said using acquitted conduct at sentencing is unconstitutional. Supreme Court Justice Gorsuch said using acquitted conduct at sentencing is unconstitutional. 17 other federal judges filed an amicus brief in the McClinton versus United States case that says that using acquitted conduct at sentencing is unconstitutional. It creates a double jeopardy. It violates the Sixth Amendment, which is the right to a jury trial. Yet, this is what went down in Puffy's case. So the appeal is locked in. We locked in. We down with Puff. We been down with Puff. We gonna stay down with Puff. The Southern District of New York, as we all know, or as I know for a fact, throughout the entire trial, even before the trial started, engaged in prosecutorial misconduct, unethical behavior, and just really tried to convict a United States citizen, a taxpaying United States citizen, of a charge for which he was not guilty of which the penalty was life in prison. They brought the charges, which should have never been brought, and they cheated to try to prove the charges, proving themselves unethical, engaging in misconduct, and forever leaving a stain on the Southern District of New York brand. And the whole world watched and saw the Southern District of New York, which is an arm of the United States Department of Justice, which is a representation of the United States of America, use prosecutorial misconduct, unethical behavior, perjury, to prosecute a black man, a foundational black American man, in 2026. Violating laws, violating ethics. Russia saw this. China saw this. North Korea saw this. The Middle East saw this. Asia, Africa, South America, the Caribbean, America watched America mistreat, over-prosecute with unethical means a foundational black American man in 2026. Why is that significant? Because of the history of this country and the way they've treated my people. I am foundational black American to the core. Proud to be it. Don't want to be nobody else. That still, in 2026, the same game is in play. And this is why countries around the world do not respect the United States of America. This is why countries around the world are breaking away from doing business with the United States of America. Because the laws that are written on the books, the United States of America can't even uphold with its own citizens to protect its own reputation, its own integrity. This is why nobody respects us. And I'm a nigga. I'm the black nigga. I'm the foundational black American, and I love America. This is my home. My blood go back to the native Cherokee. My mother picked cotton here as a little girl, 75 cents a day. On my father's side too, all my aunts and uncles didn't go to school but to the 11th grade. Didn't go to school until November, December, January, and February when it got cold and there was no crops to pick. But soon as March came, April, May, June, they had to go work in the field. They didn't go to school. They only went to school 4 months out of the year because they had to work. This is my real story. In the United States of America, this is facts. This is known. And y'all still doing the same thing. See, you got to have integrity. Above everything, the call should have been made that we got to go by the books. If we want to be respected, we got to show respect to the law. But this is why nobody respects us. And this is why America is falling as a superpower. It's no longer the number one superpower. I don't care what they tell you. China has a larger economy, has a bigger population. China is moving forward for the people. They have a strong military. Russia has already demonstrated that they have a military. Integrity never went out of style. Integrity is respected always. And we got to get back. If we ever were there, as far as my people is concerned, we never have been there. But this country needs to get back to operating from the law of the land and operating from a position of ethics. That's true government. That's true leadership. That's something to look up to. Now we know this case, and Puffy went to trial. This is what y'all gotta understand. Like him or hate him or however you feel about him, he went to trial. And a jury of 12 New Yorkers that had no stake in the game. They weren't working for the defense, they weren't working for the prosecution. They came back and freed him and said he was not guilty. Puffy's lawyers didn't make that decision. The Southern District of New York didn't make that decision. I didn't make that decision. You didn't make that decision. Nobody else in the world made that decision. It was 12 John Q. Public citizens from the 5 boroughs in New York that said Puffy was not guilty. Let him go. Sixth Amendment right. And still, they over-sentenced him for a prostitution charge. Gotta put some Vaseline on my lips so my lips could be soft when I kiss my honeys. For a prostitution charge that never should have been brought. And for a RICO charge and a sex trafficking charge that never should have been brought, but that you lost anyway. You threatened the man's multi-million-dollar empire, his assets, his publishing, his ability to support his family. He had to put all of that on the line. He had to put all of that on the line get acquitted by 12 New Yorkers and get a Mann Act conviction with an average sentence of 14 months. And because you lost, you over-sentence him on a charge that should have been Rule 29 or Rule 33. enhance him 13 levels as a first offender and give him 50 months. United States of America. And all y'all people out there, all you citizens out there, you hate Puff because of what you read about him on social media or whatever, and what other rappers have said about him, or what. None of that stuff came out at the trial. No gay stuff came out at the trial. No pedophilia came out at the trial. But you don't care that the law is disregarded and broken as long as you get a conviction of Puff, because you've been indoctrinated to hate him. But when it comes to your life, you want the law to be applied to you equitably. You don't want no breaking of the law when it come to you and your lawsuit. Everybody got to follow the law. But when it come down to Puff, fuck Puffy. Send him to jail for life. He's a monster. None of y'all never came to the trial. None of y'all never came, never stepped foot. You probably ain't never been to New York. You're dumb. And that's not right. That's unethical. And for you to sit by and let the government do a citizen like that, whether you like him or hate him, is wrong. I don't care if it was a Ku Klux Klansman or Aryan Brotherhood or skinhead that killed 3 niggas or was accused of killing 3 niggas but was proven not guilty at trial. As much as I may not agree with his ideology and his philosophy and what he believes in, he's got a right to believe in that. But if he was not guilty, set him free. Why, Sean? Because that's the law. That's the law. Because if we set the precedent with him and convict him and punish him for something he didn't do, then that means they could do it for everybody. We're setting that precedent. And that's what the Southern District of New York did in this case. They've set the precedent that prosecutorial misconduct can be used. Perjury is acceptable. Lying is acceptable. And over-sentencing is acceptable. And bringing a case for conduct that typically doesn't require a case to be brought is acceptable. That's what was done here. And then we can over-sentence. We can use acquitted conduct to go above the guideline range, violating Rule 826. That's acceptable. And we can enhance a first offender defendant 13 levels on a first offense. That's acceptable. That's what they did. And all of these rappers and all these people that hate him in the industry, the music industry, the fashion industry, is because they feared him. They feared him. It came out at the trial. Puffy is no sucker. He's no punk. That came out at the trial. The image they tried to portray that he was soft and weak, and not that. It came out at the trial. Not only was he a man's man, but he had money and power. And these niggas was intimidated by him. And the ones that was making the most noise about him was the ones that was most intimidated by him. Podcast was sold. Free Puff.